So, let's take a look why this is so damaging to Letitia James. Andriani versus State. Let's read. I know there are some people that can't read, so I will be your narrator, alright? I will read for you. This will be Reading Rainbow. Andriani v. the State of New York. Danielle Koish, Esquire. Letitia James, Attorney General of the State of New York. By Lori L. Pack, Assistant Attorney General. West Books DeBow. Synopsis. Cliffhangers, alright? So let's see the cliff notes of the situation, alright? And Letitia James was the determining factor. Defendant's motion to dismiss claim denied. Contrary to defendant's contention, the court has subject matter jurisdiction over the claim, which alleges, inter alia, that claimant was wrongfully confined pursuant to a false parole warrant. Parole officers not entitled to qualified immunity where they lacked a reasonable basis for issuing a parole warrant. Old habits dying hard, huh, Letitia? So you decide to go start targeting classmates? Be like, well, it sounded like you're starting to be cohorts with, people that might have, wanted to go ahead and try to hold you accountable for your ruling. Especially because your ruling goes against, Harris, Heris, versus New York. Yeah. So, substantiated case law, there's a reason that it's there. This was a bad ruling. All right. Decision. This claim seeks compensation for 28 days of false imprisonment in the Suffolk County Correctional Facility. False arrest and malicious prosecution stemming from an allegedly false parole violation warrant. Defendant now moves to dismiss claim on the grounds of lack of subject matter, jurisdiction, and absolute and qualified immunity. Claimant opposes the motion. The claimant alleges that on April 2nd, 2015, claimant was sentenced to a term of 4 years of incarceration plus 5 years of post-release supervision following his guilty plea to 1 count of attempted robbery in the second degree. The claim alleges that in August 2018, while claimant was incarcerated at Franklin Correctional Facility, the state brought an extradition proceeding against him in Franklin County Court on the grounds that he was, quote-unquote, wanted in the state of Florida for a crime of violation of probation. The claim alleges that on August 8th, 2018, claimant signed a document waiving extradition to Florida. That on September 7th, 2018, claimant appeared in Franklin County Court and consented to his return to the state of Florida in the custody of a duly authorized agent of the state, and that acting county court judge Derek P. Champagne ordered, inter alia, that claimant be held by docs until the arrival of the appropriate authorities of the state of Florida. The claim alleges that on or about October 11th, 2018, docs met with claimant and reviewed and signed the certificate of release to post-release supervision, and that docs and the state were aware at the time that claimant had waived extradition to Florida. The claim further alleges that on or about October 12, 2018, upon the completion of claimant's term of incarceration, claimant was transferred directly to Franklin Correctional Facility to a company called Prisoner Transport Services, which, quote-unquote, delivered claimant to the custody of the Leon County Detention Facility in Tallahassee, Florida, on October 2nd, 2018. The claim alleges that on or about November 19th, 2018, claimant was sentenced to 13 months of incarceration in Florida on the parole violation charge, and that claimant's sentence expired on September 10th, 2019. The claim alleges that on October 26, 2018, Dox lodged a parole violation warrant against claimant alleging that he failed to report to the parole officer within 24 hours of his October 12, 2018 release from Franklin Correctional Facility, failed to make his office report on October 13, 2018, and failed to notify his parole officer of a change in his residence program at Suffolk County DSS. The claim alleges that on or about March 19, 2019, Dox placed a detainer on claimant within the state of Florida Department of Corrections, and that claimant objected and did not consent to the detainer multiple times. All right? So, Department of Justice, remember, if 50 no's and 1 yes does not equal consent for a rapist, then 50 no's to 1 yes, followed by 1 yes, does not equal to consent for a illegal search. The claim alleges that claimant was transferred from the custody of the state of Florida Department of Correction facility to Dox, and that Dox transported claimant in handcuffs via a commercial flight from Florida to New York. The claim alleges that September 6, 2019, Dox personal falsely testified at a preliminary hearing at the Suffolk County Jail that claimant had been released as a quote-unquote walkout from Franklin Correctional Facility on October 12, 2018, and that as a result, probable cause of the violation was found and claimant was held in custody pending a final hearing. The claim alleges that claimant was unlawfully imprisoned for 28 days until parole warrant number was dismissed by Dox on October 7, 2019. Claimant was subsequently released from custody. Parole board reported from January 2018 attached as an exhibit to defendant's moving papers reflected that Dox officials were aware at the time that claimant had a Florida warrant for false imprisonment, but that Florida warrants was contacted and it confirmed that the state's attorney will not extradite. On August 9, 2018, claimant signed a document from Dox Inmate Records Coordinator to Ellen Jock indicating that he wished to waive extradition to the state of Florida for Leon County, Florida, VOP case number, as stated, dated 6/10/2014. All right, so this right here, this is the continuation of circumstances from 2014. All right? Anything from 2014, you do realize the statute of limitations is already up, right? It's 2024. That same day, the Franklin County District Attorney filed a fugitive information in Franklin County Court, alleging that claimant was a fugitive from justice from the state of Florida. Also, you claimed that they were a fugitive and that you had an extradition warrant, but it was not a valid warrant. It was unsubstantiated, so you didn't have the evidence to substantiate your warrant. On September 17, 2018, claimant appeared in Franklin County Court and executed a waiver of extradition, consenting to return to the state of Florida in the custody of the duly authorized agent of said state. Acting County Court Judge Derek P. Champagne issued a securing order directing, as relevant here, that claimant remain in Dox custody until arrival of the appropriate authorities of the state of New York or the state of Florida. So what they're trying to do in this situation is, while having him detained, be like, oh, we're revoking the chance of bond. All right. So flight risk factor, irrelevant. Crime factor, irrelevant. We're saying that it's denied. All right. So, all right. So if Florida doesn't extradite, they deny him the opportunity for bail. They say he needs to be detained until the powers that be in another state get their get up off their ass and go fucking get him. They don't want to do that. All right. So then, state of New York needs to give cause for detainment. Evidence that cause, that his Eighth Amendment rights aren't being, violated, over excessive bail, cruel and unusual punishment. Because, if an extradition warrant was the reason for detainment and that state never shows up, but he's still being detained, that's called wrongful incarceration. How long he's going to be wrongfully detained? Well, public interest states could be a life sentence, apparently. On October 22nd, 2018, Officer Kevin Smith executed an arrest probable cause affidavit in Florida indicating that on that day, claimant was transported to Leon County Detention Facility by Prisoner Transport Services on warrant for VOP/false imprisonment. All right? Now, what could suspending my license make it more difficult to do? Potentially speaking on the matter as being one of the people that were burglarized? A docs violation of release report signed by Parole Officer S. McHugh and Senior Parole Officer L. Todd indicated that warrant was issued on October 26, 2018, charging claimant with violating 3 of his conditions of release by failing to make his report to the parole office within 24 hours of release from Franklin County, by failing to make his office report on October 13, 2018, and thereafter as directed, and by failing to notify his parole officer of a change in his residence program at Suffolk County DSS. At the September 16, 2019 preliminary parole violation hearing, Senior Parole Officer Todd testified that claimant violated the condition of his release by failing to appear at the parole office within 24 hours of his release from Franklin Correctional Facility or to report to DSS within the expected time frame for assistance in obtaining placement in a sober house. All right? So it was their job to help obtain the placement in the sober house. So now are they going to violate him for not finding placement in the sober house when they were supposed to assist him in obtaining placement? That's not in his job description. Much prayer warrior on October 16, 2018, after determining that claimant was an absconder of parole supervision. Todd testified that it was, which, by the way, absconder of parole supervision, he was declared a flight risk. But remotely checking in is still fucking checking in. And remotely checking in, it needs to be had? Proof of remotely fucking checking in. Just because you try to take the proof away from the person that's expected to prove that they checked in doesn't mean that it didn't fucking happen. It just means that you're a bad faith actor. Claimant testified that prisoners were typically released from incarceration on Thursdays, but that he was released on a Friday because he was being released to a prison transport and it would not have been possible for him to report to the parole board the next day because the parole office was not open on Saturdays. So apparently he can control when you're open and when you're not, is what you're saying. Claimant further testified that he left Franklin County Corrections Facility on the prison transport on October 12, 2018, and that he arrived in Florida on October 22nd, 2018, 10 days later after making stops in Buffalo, Poughkeepsie, Rochester, West Virginia, and Georgia. SBO Todd then testified that P.O. McHugh had contacted Franklin CF, who said they did not have a record of claimant being released to a warrant and that he was released as a walkout. Todd further testified that he also made a phone call after docs learned that claimant was in custody in Florida because we wanted to determine if he had in fact been released, and we determined that he was. SPO testified that when contacted the facility in Florida, the information was relayed to him was that the claimant was held on Florida warrant and that he was given no information that claimant was held on a warrant prior to that. So he didn't inform who needed to be informed. Claimant then stated that he had paperwork to prove that he had been picked up at Franklin CF by the Prison Transport Service and had taken to Florida, and that he was in custody in Leon County, Florida from October 22nd, 2018 until he was transferred to the state penitentiary in December 2018. Preliminary hearing office found at the conclusion of the hearing that docs had met the burden of proof through SPO Todd's testimony that there was probable cause that claimant violated the condition of his parole, set a final hearing in October 19th. However, on October 2019, before the final hearing could take place, claimant's delinquency was canceled on the basis of alternatives or information not available at time of DD. In support of its motion, defendant argues that this claim must be dismissed for lack of subject matter. Jurisdiction between the claimant is seeking judicial review of the determination rendered following the preliminary parole violation hearing, which must be brought as proceeding pursuant to CPLR Article 78 in the Supreme Court of the habeas corpus proceeding. In opposition to the motion, claimant argues that it is not the hearing officer's determination that forms the basis of this claim, but rather the utter failure of docs to exercise any sort of reasoned judgment or discretion, and the abdication of their duties insofar as it pertains to the issuance and execution of parole number 762210. Claimant argues that a habeas corpus proceeding cannot be brought because claimant is no longer in custody, and CPLR Article 78 proceeding is not an appropriate remedy because the underlying warrant was canceled and has no further negative effect. Public perception is a negative effect. Claimant argues that the court has subject matter jurisdiction over the claim because docs had actual knowledge that claimant had appeared to be at an extradition hearing in Franklin County Court and was transferred from Franklin County facility directly to the state of Florida. As framed by the parties, the question of the court's subject matter jurisdiction over this claim, more specifically, whether this claim must be brought in Supreme Court, centers on whether, as defendant asserts, the claim is based on the hearing officer's determination following the preliminary parole officer hearing violation, or, as claimant counters, the claim is based on doc's issuance of a false parole violation. A review of the claim reveals that it asserts causes of action for unlawful arrest, false imprisonment, and malicious prosecution of claimant, based upon the intentional malicious neglect, carelessness, recklessness, and gross negligence on the state and docks. Getting the point?